First District Court of Appeals now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Good morning and welcome to the First District Court of Appeal. We have two cases on our oral argument calendar this morning. We'll take them in the order that they were published. The first case is case number 24-2227. Frency Moore and Yuri Ramos as personal representatives of the estate of Celia Lario versus Billy Ray Bowman et al. Appellant's counsel?
Yes, Your Honor.
If you're ready.
Thank you. I'll have 3 minutes for rebuttal, please.
You said 3?
Yes, Your Honor.
Thank you. Noted.
Good morning. Your Honor, we have the pleasure of representing Ms. Lirio. Obviously, this is a dram shop case, Your Honors, and our position, obviously, is that a reasonable juror could find that Mr. Bowman, the drunk driver in this case, was a habitual addict. We start with the fact that the bartender, one of them was an elementary school friend of his. That's record 2281. The other bartender was a girlfriend. One of the other bartenders was his girlfriend. That's record 1721. Before he walks in the bar that night, we also have evidence that he had blacked out drunk in 2019. That's record 155.
Well, counsel,
yes.
Before we get into the specific points of fact that you believe supports your position, I want a little bigger picture on the Dram Shop Act. My first observation when I see this is that the Supreme Court has said a number of times that Section 768(1)25 does not create a cause of action. What it does is it simply opens the door to a different cause of action, negligence cause of action, a wrongful death cause of action. Generally, the door is closed, right? It's an immunity statute, but there are exceptions that allow suit. So if 768(1)25 does not create a cause of action, which is very clear from the Supreme Court, how is it that the cause of action is specifically driven by what the statute says and what the statute requires?
Because common law, there existed negligence actions, right? And then the statute says you can't sue these bar owners for policy reasons except in these circumstances. So then you have to craft your case around those limitations set out in the Dram Shop statute.
Right, but the cause of action is a negligence cause of action.
That's correct.
So it seems to me that this is really a legal question for the court to determine whether the defendant is immune from suit at all.
That's right. And
if that's true, why do we even apply the summary judgment standard? If it's not going to go to the jury, if the jury is not responsible for determining whether your client was habitually addicted to alcohol, why does summary judgment even apply to this? The jury isn't there to find whether your client is habitually addicted to alcohol because this isn't a cause of action. The cause of action is negligence. So why is summary judgment even the right tool to raise this claim?
Well, that's a good question, Your Honor. The habitual addict part of this is a legal determination. I agree with you. We feel that the court respectfully made the wrong decision on whether or not there was a question of fact on that issue. And I think what Your Honor is saying is that's not a question of fact, it's a question of law. Therefore, why are we talking about this? And right. I don't disagree with you. I think this is a new or should have known standard. Like all other negligence cases, and this court is well aware of the Faircloth decision where y'all dealt with the other part of the Dram Shop statute and basically said, yes, comparative negligence does apply. So these principles that you're talking about do apply to the ultimate negligence case that would exist before the jury. Did the bar act as a reasonable and prudent bar in carrying out its procedures to determine whether or not this person should have been served or not? So I agree with that.
So it seems to me that there is a plethora of evidence that Mr. Bowman had way too much to drink that night. That is not in dispute at all. But what you have to show is the bar knowingly served a person habitually addicted to the use of alcohol. So a pattern, I think the Supreme Court called it in one place, a class of persons who lack the ability to make a responsible decision in the consumption of alcohol. So clearly, he made irresponsible decisions that night. But what evidence is there that he belongs to a class of persons who lack the ability to make responsible decisions?
Your Honor, I was going through that list. We've got a 2019 blackout drunk, 155. That's a year or two before this. Counseling for alcohol issues, that's record, let's see. Counseling with Dr. Shi Maria, that's record 657. That's in 2019 and 2020. Also referenced at 2286. The bar knew, before he walked in the bar that night, they knew him. He's part of the service industry in that little town. This is Orange Beach, Perdido Key. Y'all know what this is. And so we've got a service industry night. This is called SIN night, Service Industry Night. And that's where they give discounts to all the people that work in other restaurants and bars. Mr. Bowman was a member of that service industry community, and that's at 1048 in the record, Your Honor. It's a small town. That's at 1046 in the record. The bar's not busy. That's at 1253. Social media, as your honors are well aware, when you publish things about your drinking habits on social media before this happens, that gives the bar notice that you have a drinking problem, especially when the bartenders are friends with you on social media. So if I'm answering your question, that's at 741 and 2283 in the record. The social media posts that you yourself publish to the world and you say that your only drinking problem is when you run out, that's at 2298 and 498. That night, before he walked in the bar, we also had a report from another driver that told the extra duty police force that was working at the door, the person in that red Jeep was driving like a person that was drunk. And the deputy said, he went and told the deputies at the front door of the Floribama that person had been driving erratically. That's at 1914 and 1919 in the record, and 1956 and 1958 of the record.
So what I'm hearing from you is that his actions are somewhat episodic. And I guess I'm wondering, under the standard that Judge Roberts just read, I think from the Ellis Supreme Court case, this idea of the ability or lacking the ability to make responsible decisions, can that be episodic? I mean, can it be, I'm very responsible with my alcohol Monday to Thursday, but on weekends, I'm all over the place? Does my control Monday through Thursday obviate this rule, or can it be episodic? Or can it be just on the big holidays? I get blowout drunk and I'm driving all over town. That's just the way I do it. The rest of the year, good. How do we deal with that?
Judge, the statute doesn't say alcoholic. Alcoholic is a diagnosis that sort of pervades you forever. That's something that you can't get away from. The statute says habitually addicted. In other words, you have a habit and routine of when you drink, you can't stop. When you drink, you have trouble saying no. And so to answer your question directly, I think it can be episodic. And obviously these social drinkers can also have a problem regulating how much they drink when they drink.
So is there any evidence of the record of Mr. Bowman going to a place and having a couple of beers and going home, like, responsible drinking?
Yes, Your Honor.
So there's evidence of that?
Yes, Your Honor. There's plenty of people.
So he's not one of these people that, if he has one drink, he's going to have 20.
I don't think that's what this case shows.
He had way too much this night, right?
Yes, way too much this night. We have, there's video, 4 drinks in 23 minutes. And there's a question of fact of whether those are doubles or singles. 4 drinks in 23 minutes. So, and to answer your question.
Well, that's why I'm trying to narrow in on the habitually addicted part. Because, if we were in a state that had a regular dram shop law,
right,
this would be a great case for you. It would be easy peasy. But we don't have a regular dram shop law. 3
feet away from this office, Your Honor, in Alabama. Yes, correct.
Right.
This is on the state line. Right.
Yeah. So, and that's why you have a very much tougher case.
That is correct.
You have to show he's habitually addicted.
That's correct.
And you just said there's evidence in the record that he is able to drink responsibly, but on this night he didn't.
That's correct. Well, I didn't say that it was my opinion that he was. The question was, is there evidence in the record that he did drink responsibly? The honest answer to that question is yes, there is evidence in the record. But it comes from people that are his family. The two people that were in the car with him that night, they were also drunk and got kicked out of the bar. Mm-hmm. So the sentencing judge, Judge Simon, looked at this defendant, and this is in the record too, and said, I don't think you're being honest about how much you drank that night, to this court. And so to answer your question, the record does have evidence that he drank responsibly on occasion, but it also has record that night he was showing an intemperance to being able to control his drinking habits. Mm-hmm. And isn't that what these courts are for? To determine whether or not there's a question of fact on these issues. And so it's...
And there's something habitual about the fact that on that night he had drunk too much, right? It's habitually addicted or habitual drunkard, I think the Ellis case talks about.
Right.
So there has to be something habitual about that kind of activity, even if maybe what you're saying is even if there's evidence that he can also at times drink socially one or two and be done, there's also this other evidence. Is that what I'm getting from you?
Your Honor, I think the counseling in 2 years before this for being blackout drunk, that didn't follow everybody around in their life. Not everybody has counseling for alcohol, drug addiction, where you get blackout drunk and you have to seek counseling. That happened before this.
So what was the nature of that counseling? Did an employer send him to the counseling, or was it a court? What happened?
I don't believe it was court ordered. I believe, frankly, I don't know. I'm sorry. But it was a licensed mental health counselor, licensed mental health counselor, She Maria, has in her records, and again, I pointed out to Your Honor, that was at pages 2286 of the record. And it related to an episode where he had some issues with his family, I believe, Your Honor. And if I'm not mistaken, grandfather passed away somewhat recently to that time, and he went through a period of time where he was binge drinking, I guess they called it, and he blacked out drunk at least once. So that is something that obviously is in the record that shows that this is not like a one-time thing. And I feel like the dram shop statute in Florida was actually created from a policy standpoint. We're the state of tourism, right? And, okay, you can't have bars having these people from out of state come in one time, get drunk, and get sued. That's not going to work here, right? But this is not that person. This is a person that actually lives in the local community, frequents the bar. The bartender knows his drink of choice. Let's see where that is. Record. $10.48. And so it looks like I got yellow. So I'm going to stop and save my time for rebuttal unless Your Honor has a question. Thank you.
Thank you.
Thank you.
Thank you. May it please the Court. So as Your Honor mentioned a moment ago, we were concerning what's the real meaning of 768.125 and what does it mean, okay? And what that is, as Your Honor so stated, is a shield statute. And it is referring to what it does is it protects sellers of alcohol, who's a legitimate business, from liability based off of what their patrons do once they've drank alcohol. And it represents a policy decision by which we are going to blame the drinker of the alcohol for...
So isn't the knowledge of all the agents of a principal imputed to that principal?
Yes, Your Honor.
All these employees that knew Mr. Bowman, the stuff that they knew about him, isn't that imputed to the Floribama?
Well, yes, Your Honor, but the issue is what did they know, and what they know is that he's not a habitual drunkard. We continue to act as if that is not an important issue. Knowledge of someone being a habitual drunkard requires them to meet the definition of habitual drunkard. And if all of the bartenders know him and know he's not a habitual drunkard, that doesn't convey knowledge to the organization that he is one, right?
But that's sort of a fact, that's a fact issue, right? That's a credibility call as to the witnesses and a fact issue.
Well, it is a fact issue to the extent, but we have to have countervailing evidence. It's not like the court is weighing, oh, I have 5 witnesses that say he's a habitual drunkard. Is not a habitual drunkard. He doesn't drink excessively. He doesn't have an addiction to alcohol where he can't stop drinking. I have 5 witnesses say that, but we don't have any evidence that says he is one. Right? We're attacking this as if if there's an issue of weight or credibility or something else like that. But there's actually no evidence whatsoever that he is a habitual drunkard. His friends say he's not. Right? The fact that we mentioned
How about the counseling and the blackout situation and that other evidence that maybe leans the other way?
Well, as the trial court found in its order, is that that's not evidence of someone being a habitual drunkard. If someone is drunk once in 2019 and gets blackout drunk and doesn't drink again, that's a sign that they're not one. Or they decrease their drinking. And this is not, we're characterizing this as if he's seeking counseling for alcohol. He's not. He's seeking counseling generally, and as part of that counseling, he mentioned that when his grandpa died, he drank too much. Okay, and part of the counseling is that he agreed that he's to slow down his drinking because it wasn't healthy for him, and he did that. And so that's the opposite of how plaintiff is producing this, because if you had an issue where you have a one-time situation where your grandfather dies and you get blackout drunk once, and then you don't get blackout drunk for the next few years, that's a sign you're not a habitual drunkard.
How about if it's once a year? Every New Year's Eve, I'm gonna get drunk and I'm gonna drive around. That's what I do.
Well, that shows control, because it shows you're able to control until that once a year. If you have blackout drunk every Friday night, it shows you have control, right? Because this statute, it says let me rephrase this. The Ellis
So controlling yourself Monday to Wednesday is enough control that you can blow it out every weekend and drive around, and that's not.
I think yes, because the issue is the way that Ellis phrases what a habitual drunkard is. It's not someone who has an alcohol problem. It's not someone that drinks too much. It's not. The problem is someone who has not. The exact phrase is a class of persons who lack the ability to make responsible decisions in the consumption of alcohol. Not that they drink a whole lot when they choose to drink. It's just they can't make that decision. It's a mens rea issue. What we're saying is we're not going to blame the tavern for the consumption of alcohol. We're going to blame them only if they know that they don't have the capacity to make that decision. So essentially, is the tavern's making that decision for them. And that's the only time that we're ever going to have liability here. And we can't, in every case where where a tragedy has happened, we can't go through and just pick apart, one time 3 years ago he drank too much. One time he told his friend that, alcohol wasn't a good thing to have. Or one time he made a bad joke on a Facebook profile that, his only problem is when he runs out of alcohol. When we pick apart these things, that's not evidence of someone being a habitual drunkard. It's not evidence that can be weighed at all, let alone by a jury. That sort of analysis is exactly the kind of effort and work that they're trying to avoid by having this shield statute.
So how much weight should we give to the sober drunkard theory? Because at least Mr. Bowman's on film, they don't have hard evidence of what he had before he got to the Florida Bama bar, but he had 6 drinks in about 50 minutes at the Florida Bama bar, and it's on video, right? And he appeared to be completely sober after those 6 drinks, even if they were singles. And his buddies were so drunk they got thrown out of the bar.
Yeah, they'd been thrown out.
At the same amount of time. So wouldn't their argument is a bartender should know someone that can drink that much and appear to be sober is a habitual alcohol abuser? Well,
I want to say, first of all, this is I don't think it's good law anymore, but I want to go kind of a little bit more basic. And I want to state that what that test does is determine whether there's a triable issue under the old summary judgment standard, when there's like a scintilla of evidence, that allows them to go to trial on the issue of knowledge. It does not establish that he is one, right? Because if he is unable to control his alcohol every day, no matter, if he's unable to control his alcohol consumption, we're going to have evidence that that's the case. And the roster court, which is the sober drunkard test came from, that was already established that he was a habitual drunkard. So it's only a question of whether we can get a little hint, whether there's a hint of knowledge that can be taken by the jury to establish knowledge of that fact. But we're completely ignoring the fact that there's no evidence that he is a habitual drunkard in this situation. So in
How
other
about
words,
the social media post or the joke, to the extent of the only alcohol problem I have is when I don't have any alcohol?
yeah, it was supposed to be from a song lyric, apparently, based off of so it's not like he's telling the world, I love alcohol and I can't stop drinking it or something.
That's what it seems like that would.
Well, that's
how
an
you take
implication, but we
So in
have-
your view, this statute would only allow Otis from the Andy Griffith Show to be sued? Just Otis, you know who I'm talking about?
I'm sorry, I did not actually catch what you
Okay.
said. My apologies.
It's an old show where there was a town drunk and everybody knew he was the town drunk. And-
Okay. Well,
Yeah.
well, I mean, essentially, the idea is we don't want to have a tavern that's just, got somebody that's just, willing just to throw all their money out every night. Like, sure, we'll take your money and let you drunk every night. If someone shows up on occasion and sometimes drinks, heavily, that's not, habitual drunkard, under the statute. And so, what we're doing here is we're splicing together evidence of someone who, piecing every little piece of their life to try and establish any sort of alcohol use. But the reality is the fact is that there's an absence of it, right? If we have 5 witnesses that are saying that he doesn't do this, where are the 5 witnesses, or the millions that there should be, or any one at least, that's saying that he does have this problem? It just doesn't exist. And, this statute, the Shield statute, does not work if we can't, knock out cases like this before we go to a jury. Because a jury is going to be, someone died, it's terrible. And there's someone that did something terrible. They drove after drinking too much. They drove after drinking irresponsibly, and they killed someone. It's terrible. And a jury is going to hear this, and they're going to be very sympathetic. And I don't know how that's going to turn out. And if this goes to trial in that way, we're going to have a situation where there's no evidence at all to support the plaintiff's claim, but we're piecing it together to make it kind of sound like, this person is a drunkard. And this sober drunkard theory, I'm sorry, let me get back to that. This idea behind it, of course.
So the judiciary should not really trust the jurors to apply statutes that we instruct them on?
Well, of course, we do trust the jury to come to these conclusions, but when you have an issue of law that's very specific, that we don't have to risk that sort of mistake being made, it's better to do so. From the perspective, because the reality is there's no evidence to indicate that this person was a habitual drunkard, that they could not control their alcohol consumption, as we just heard. That's the case. Now, and to emphasize about the sober drunkard, the only evidence apparently might be the sober drunkard theory that we have. And there's just so many problems with that, obviously beyond just the knowledge issue. First is that the video that we talked about, as the trial court found, does not actually show 6 double pours. You can't even see the pours being made. It just doesn't show it. And we're presuming that they're double pours for some reason. And we're presuming it based off of that the manufacturer's website said that up to 1 ounce can come out every second. Up to, not it does. And not it does
Well,
every
even if they're
circumstance.
single, 6 highballs in an hour is a lot of booze, right?
Well, hypothetically, 6 drinks, yeah, absolutely. We're not questioning he's drank too much. If the idea is that, should he, morally or appropriately not have drank that much, of course not. But the issue is that, they're not double drinks. He didn't drink all of the drinks. The observations about sobriety, of course, there are some about sobriety, but even Preston Rideout, in his deposition testimony, who is the expert, stated that he did look drunk. The people that were there just didn't notice him, okay? So, and they just didn't testify to it. So, there just isn't evidence that he is a habitual drunkard, and it just doesn't exist.
Counsel, let me ask you, shift back to the definition from Ellis of the statutory language. This is a little tough to nail down, habitually addicted to alcohol. But both of you have used the standard from Ellis, which is a class of persons who lacks the ability to make a responsible decision in the consumption of alcohol. But there's this case from earlier that used the phrase habitual intemperance, which is completely different. It's from an old, I think, a divorce case. And I did see that phrase used and the language from that case used in the order. Did the court apply the correct standard? And is the correct standard the standard from Ellis?
That's
And if
right.
so, when they mentioned habitual intemperance from this other case, this Sabo case, did the judge apply the wrong standard in determining when someone is habitually addicted to alcohol?
Well, the court explicitly stated it used the Ellis standard and didn't cite to, I believe it's a Cabo, or is that the case?
Sabo, I'm pretty sure.
Sabo,
Pretty
sorry.
sure he did.
It didn't even cite to Sabo. And so now, it's possible there's a reference to it, but it didn't base the decision off of it. It based it off of Ellis. So, I mean, perhaps it had the word intemperance in there, but all the citations are for the Ellis and the Ellis standard. And I don't really understand what the distinction is supposed to be, because I don't believe that was an argument that was brought, in terms of habitual intemperance, or, how that would be any different. I'm not really sure what issue my opposing counsel is bringing up when he suggests that the court was using that standard, because it seems pretty clear to me that it used Ellis. And it's, progeny. Now, they might have had reference to it, several case law discussing, concepts related to it, but they're not, the court was clear on how it made its decision. And I do want to also emphasize, about the only thing that we have here is that, that sober drunkard test. Further, the court found that there was, that there wasn't good input because we couldn't see the videos. The methodology was bad because there's no, it was based off of the manufacturer's statement. And it doesn't really make sense as applied to this case, because in this circumstance, for the logic of roster to apply and the sober drunkard theory, you have to have someone that observes someone drink excessively and then see that they are able, that one person sees that they're able to apparently hold their liquor as if they weren't even drinking, and then they serve them afterwards, right? So we don't even have that here. We have someone that had 5 drinks somewhat quickly and then left. Now, the agency issue that we're talking about here, I do want to get back to that and say, aren't we going to presume that all the people who served him drinks, that information is going to be brought together? And I want to state that that's not really, agency law can allow you to convey something meaningful that happens, but not something, the fact that one person had a drink, that a particular bar patron had a drink, and in a whole other room, another bartender saw that that person had a drink in that other bar. It doesn't make sense for us to just presume that disparate information that's not important would be conveyed, to the principal. Of course, we want to have a rule where an agency that we don't, we want to encourage the company to ensure that they have information that they don't want to have to say, well, we didn't know about it because nobody told us about it. But that's not the situation here, because this isn't a relevant piece of information that's coming in. It's information that only becomes important because it's synthesized by 3 different people in real time. And so it's just logically absurd to hold this bar responsible for knowing exactly how many drinks this person had, and exactly, the way he looked, when there's 3 different rooms and multiple bars in each one of those rooms. To hold the tavern responsible based off of just that information, it's sort of a logical absurdity. Let me see here, 37 seconds. I just want to also emphasize that the expert affidavits here, there's no information that they conveyed. All they took is information that they did not drink, and then later characterized that. And so it's inappropriate.
You may briefly conclude.
Thank you so much. I honestly, that was pretty much my concluding point. Thank you.
Thank you, Ms. Huber.
The Facebook post, I'm sorry, the Instagram post was 2 years before the song came out, to start with. So we've got a guy holding Devil's Cut Jim Beam with a glass, no mixers, warm liquor, drinking it straight from the glass in 2015, before this song came out that has the lyrics that they're suggesting. So then we've got a guy that's drinking on the beach warm gin with his buddies, no mixers. Then shows up at the floor, bam, and drinks, as Judge Roberts pointed out, 6 drinks in less than 50 minutes.
Counsel, I want you to address something that the trial court said that I'll read to you. It's about the fact that he may not have appeared drunk at the bar. The judge wrote, the observation that a patron doesn't appear intoxicated after drinking will necessarily occur after the patron was served. Accordingly, the wrongful service of alcoholic beverages could only occur at some point in time after the patron had already consumed an extraordinary amount of alcohol and sufficient time had passed for the patron to appear more sober than he should be. What's your response to that contention by the trial judge?
I think that's half accurate. I mean, I think that, yes, if you just have 3 drinks in an hour, maybe you should have to wait the whole hour to determine whether or not the person has the effect of alcohol. But we've got a guy that had 3 drinks in 20 minutes. And we contend, and we feel like there's evidence, there are 3 doubles.
So at what point should they not serve him because he is apparently an habitual drunkard, habitually addicted?
I would suggest it would be 1 drink an hour, and if you're doing more than 1 drink an hour, there should be some red flags that go up on your staff's part. If you drink 3 drinks in 24 minutes, somebody should be sounding alarms about that person.
So habitually addicted doesn't have to mean, what you suggested in other evidence, that he walked in the bar, they know that guy is habitually addicted to alcohol, but that it can just sort of create over time simply by his drinking and his reaction to it. You can make the conclusion at that point?
Your Honor, I think that a responsible bar should train their bartenders for that reason. Yes, Your Honor. I think that that's one way to get to the habitual addict status, is that way. The other way is to have all this circumstantial evidence that we do have in this case. She said that
And there are a lot more variables. I mean, I don't know how big a guy Mr. Bowman is, but I mean, if the guy weighs 120 pounds, the alcohol is going to hit him a lot quicker and have more effect than if the guy weighs 260. And if the person is drinking on an empty stomach, it's going to be different when if they just had a big meal, right?
I think that's true, Your Honor. But when you're training bar staff, I think you use generalities for the average person. And in this case, obviously, they said there's no evidence that he had a habitual addiction to alcohol. So we obviously disagree with that.
Thank you.
Thank you, Your Honor.
Right, and we'll call the next case as soon as the next counsel comes forward. All right, our second case this morning is case number 24-2483, Brevard HMA Hospice versus VNA Hospice of Indian River and the Agency for Healthcare Administration. Appellant's counsel.
May it please the court, Jeffrey Smith on behalf of the appellant Brevard HMA LLC. I'd like to reserve 3 minutes of my time for rebuttal.
Noted.
Your Honors, this is a certificate of need case, and the issue before you is whether the Agency for Healthcare Administration erred in denying a CON application for a new hospice program based on the not normal circumstance of an existing monopoly that deprives residents of a choice in their end-of-life care and the proven special circumstance under ACA's published hospice rule of a lack of adequate service to a specific terminally ill population group, namely African American and Hispanic minorities.
I'm sorry, we need to get the clock started. Thank you. You may proceed. Sorry about that.
Let me start by addressing the standard of review in this case because I think it's significant. There are really 2 standards, as this court recently observed in the Hope Hospice case, which I'm sure you're familiar with. The 2 standards of review at play are, first of all, a statutory standard that holds that when a final order granting or denying a CON application is appealed, Florida law directs the courts to affirm the final order of the agency unless the decision is arbitrary, capricious, or not in compliance with sections 408.031 through 408.045. The second standard, though, is a constitutional standard, and that is when interpreting state statutes and rules, we no longer defer to the administrative agency's interpretation, but interpret the statute de novo. And it bears reading that constitutional standard is that in interpreting a statute, Article 5, Section 21, or rule, a state court or an officer, hearing officer, or in an administrative action pursuant to general law may not defer to the agency's interpretation of such statute or rule and must instead interpret such statute or rule de novo.
But you're acknowledging that in applying the law to facts, that the statutory standard of arbitrary capriciousness, lawlessness is the bar.
What I would say, Your Honor, is no. I think
Yeah,
that
I didn't see it in your brief.
I don't believe that to be the case. And I think that you have to read the entirety of that statutory standard, and the constitutional standard tempers it. Because if you simply said it's an arbitrary and capricious standard, then you've revived what the people of Florida voted to overrule and amend their constitution.
So the statute is no longer good law.
The statute is good law in its entirety because it doesn't just say only arbitrary and capricious. Even under the old defer to the agent, arbitrary and capricious action is always going to be a basis to overturn. But what this statute says, both things, arbitrary or capricious or not in compliance, and that's where the de novo.
So you're saying if they read the law wrong, we're going to read the law de novo and make sure that it's right.
Absolutely.
But
Absolutely.
conversely, if they read the law right and we agree with their interpretation, then we should affirm.
That's true, Your Honor.
But in this case, more about the facts, in this, aren't you asking us to find that the ALJ in their fact-finding function got it wrong and we should find different facts?
No, Your Honor. This is a legal issue, and if we look at the precedent of the ultimate holding it has to do with establishment of a not normal or special circumstance that overcomes a numeric calculation of need. There are guideposts, and there are specific statutory provisions at issue that this court should look at the evidence as found and apply. And that's the key, Your Honor. So a couple of quick hospice fundamentals, because sometimes people who don't work in this area don't really understand all the basic fundamentals of hospice. Hospice is end-of-life care. It's for terminally ill patients. It's a Medicare benefit. It lasts up to 6 months. So the whole idea is not that you get somebody on their deathbed in the last few days of life and provide hospice care. It's you provide hospice care during that last 6 months of life. And so getting patients into hospice earlier is an accepted goal of hospice. The record is replete with that. Nobody disagreed with that. It's also home-based care. And that's important because sometimes people think of it, it's a building. It's not. Hospice care is provided in a home, in an assisted living, if that's your home, in a nursing home, if that's your home, in your private residence, if that's your home. Why that's important is because people with hospice care, different from other healthcare services, if you're having an issue with access, you can't just pick up and leave and say, well, I'm going to go across the county line and get my hospice over there. Can't do it. Not with hospice care. And so it holds a special place in healthcare because it is such an important decision to families and to patients and their families. And that's why the legislature, in looking at certificate of need, set up a special provision for hospice care. It's marked 408-043, special provisions. And for hospice care, the special provision made clear that monopolies in hospice are to be discouraged. And that is...
Why didn't it say county line monopolies? It seems like you're putting emphasis on the fact that each county is its own discrete area and things don't go across counties, but here it talks about regional monopolies.
Correct, Your Honor, and you have to understand, again, that there's 27 service areas in Florida. They're not all single county service areas, but there are single county service areas. And what the case law has held, let me just go to as to regional monopoly, this final order on appeal here found that a single county can constitute the regional monopoly, and that's established in the final order itself, as is it can be a single county, as is the case here. That was also the case in the Tidewell versus Sarasota case, which is cited in my brief, where in response, in the responsive briefs, they say, well, Tidewell was a monopoly in surrounding areas, but the holding has to do with a single county service area of Sarasota, and they found that the monopoly was a reason to overcome the numeric need because it was coupled with a finding of a special circumstance under the rule, a population not being served. And those two elements exist in this case. You have a monopoly, that's not in dispute, and you have a special circumstance established in the rule as recognized in the final order itself. And that is where this court should look at the total holding and say those two things in a de novo review overcome a numeric calculation of need.
Counsel, if ACA, I presume the service areas are established by rule.
They are.
Okay, but what the statute says is regional monopoly. So aren't we really deferring to the agency's definition of regions if we simply engraft their service areas into what a region is in the statute? Can't we decide for ourselves what the statute means by region instead of just saying that, well, ACA says that a service area is a region, so therefore a service area is a region?
You could, Your Honor, but it's not been appealed, and it is in the final order in this case. It's also in the final order in the Sarasota case. You're not bound by it, and you could make a de novo.
We're not required to defer to them.
De novo review. You could make a de novo review. We would say that it would make no sense to say a region is outside of the area that the hospice is serving, because the point of the anti-monopoly provision is you want people to have a choice in their end-of-life care. That's why we discourage monopolies, and to say, well, it's in other counties where this hospice doesn't exist, or where people can't go to those other counties to get their care. That's why the legislature did this. I just want to read from Compassionate Care. This court decided, the legislature made clear that to the extent possible in government-controlled industry, the economic value of competition was to be promoted and regional monopolies discouraged. This pro-competition, anti-monopoly sentiment is reflected in the administrative rule that governs how an applicant can obtain a certificate of need despite the ACA's determination that no need exists.
Didn't we explicitly defer to the agency in that case, though?
No, I think
In Compassionate Care, we did not defer to ACA in rendering our decision?
Well, in Compassionate Care, the court was troubled by the existence of the monopoly. This is pre-Amendment 6, and so they did apply a deferential standard. And as I said, the new standard of review since subsequent to Compassionate Care is a de novo standard of review, looking at that monopoly provision. I don't want to overlook the Tidewell case, because that's important, because it went up on appeal, it was PCA'd here, but the final order in that case involving Sarasota County found that the the agency took the time to say, one, there was a monopoly, and whether you call it a regional monopoly or a monopoly, it deprived people of choice. And they took the time to rewrite what the administrative law judge had found, and they overturned it and found that that monopoly situation combined with a special circumstance, in that case it had to do with outmigration, but it was that provision of the rule that says if you prove a special circumstance, the provision in the rule is approval under special circumstance. If you prove the special circumstance, then you can be approved despite the lack of numeric need. When you put that together with the monopoly situation, that is why it's a compelling case to find de novo that people in Indian River County deserve a choice in care.
But the other side of that calculus, and there's all these factors that go into the weighting, is who the applicant is, right? And what is that applicant offering to provide? If I go in there and point out, hey, it's a monopoly and certain people aren't being served, I don't have any experience in running a hospice, and I would expect to be denied, even though I've pointed out these faults in the county. And so the other side of this seems to be, and I believe what your colleague argues is that in the findings here is this 408-035-5, the extent to which the proposed services would enhance access to medical care, that there's a shortcoming there. The applicant didn't come forward and show us how they were going to make things any better.
Right, and I would say they as a matter of law, that conclusion, as to enhancement of access, it misses the mark. And I want to, and I'll segue into this discussion about the Medicaid managed care, because black and white law, the agency is told in statute that the agency, in a section that is marked access to care, the agency is told that for Medicaid managed care patients, the agency is told in the statute that for all health services, there's a mandatory obligation to establish adequate network standards to ensure access to care. What did they do? They put it in the contract, just as they're directed to do in statute to establish contract standards. They put it in their model contract that they use, that there shall be a minimum of 2 hospices per county. The only testimony was that is there for a reason, and that reason is to provide a choice in hospice care and ensure adequate access to care for residents. So I think they missed the boat on the issue of access to care, Your Honor. On the special circumstance, the agency took the time in this order.
You're into your rebuttal time. Just to let you know how you want to apportion your time.
I'm gonna reserve the rest for rebuttal. Thank you, Your Honor.
Good morning, may it please the court. I'm Sean Frazier from Parker Hudson, represent VNA, the appellee. I'm joined by Julia Smith from the Agency for Healthcare Administration. I'm going to do my best to stick to 8 minutes of time and reserve the rest for the agency. I'll start, I guess, with the standard of review and make sure that the constitutional amendments that have happened recently don't confuse what's still the review standard for this court. Unless the court finds a ground for setting aside or remanding this action, it shall affirm the agency's action. And if the order depends on findings of fact found by the ALJ, the court may not substitute its judgment as to the weight of that evidence. The appellant's case, I think, almost entirely is based on a request that this court reweigh the evidence and decide what special circumstances it thinks are supported by competent substantial evidence should outweigh other findings of fact made in the order that were supported by competent substantial evidence. The standard has not changed. Just as recently as a few months ago in Hope Hospice, in a 2025 case, Judge Osteras was on the panel, they applied the exact standard from 408-039 that you asked about, that still uses the words arbitrary, capricious, or doesn't follow the standards of the CON statutes. I think they can be read in context and still make the statutes make sense. Arbitrary is without logic or reason, on a whim, capricious. That's almost the same as the competent substantial evidence. If there was no evidence to support a finding, you can't support it. It's arbitrary, it's capricious. But in this case, that's not what happened here. For each of the special circumstances argued by the appellant, the evidence of the record was, those are great ideas. You threw everything at the wall that could be a special circumstance in this community, but you didn't show you how we could fix it. What does Brevard HMA do that might be able to fix it, or is it really a problem? And in just a minute, if I may.
So there is an identified problem, but their application just didn't ring the bell. They needed more in their application or in their showing?
That's, the final order found that 3 out of the 4 special circumstances they maintained throughout the trial were indeed special circumstances, but because they applied their rule and the CON statutes properly, their rule says that's not enough. You have to have special circumstances in the absence of need. This community is already well served by just one provider. But that's not enough. It's got to outweigh the other criteria, and as Judge Wincover just pointed out, 408-035 sub 5 requires the applicant to enhance access, do something to fix it. I'll give you an example. African American Hispanic access is an endemic problem for hospice access. Some folks just don't trust medical providers at the end of life. Some folks have religious objections. Some folks rely on their family. It's very hard to overcome those barriers. Every service district in Florida, and I would represent every place in America, has a lower service of hospice for African Americans and Hispanics than do white populations receive. It's an endemic problem. So yes, that is present in Indian River County. How do they fix it? Our provider in a much smaller county with many fewer Black and Hispanic deaths served more Blacks and Hispanics than Brevard HMA did in a much larger county right next door. The findings of fact also established they don't have outreach programs. My client, VNA, establishes a bus, gives rides, does screenings, reaches out to the Black community, had witnesses from the Black community saying these people are in our rooms every day, we know we can trust them. Nothing similar was offered in evidence by Brevard HMA. I'll just briefly touch on the other special circumstances argued. The average length of stay argument was rejected as a special circumstance by the agency, we think properly so. The evidence showed that there were 6 hospitals that all have dying patients in them in Brevard. There's hospitals in Indian River County too. Brevard HMA works with every hospital. Everybody who's dying doesn't know they're going to die in 6 months. Many people only find out a few days before, and they're all deserving of a hospice. If you serve all hospices, you will have more short-stay patients because you're serving those hospitals. Brevard HMA only contracts with 2 out of the 6 hospitals in its own county. It doesn't feel its responsibility to serve all hospital patients. And what's the result? It gets the longest staying, most profitable, cream of the crop hospice patients, and then cynically says, VNA is the one that has a problem because your length of stay is too short and you're not given the full hospice benefit. It's a twisting of the facts, and the judge saw through it. The court, the agency did as well. 2 more just briefly. Regional monopoly can be a special circumstance, but there was not competent substantial evidence in this record of any monopolistic effects. There's no price competition in hospice. Medicaid pays the same as Medicare. It's all standard. 90% of all patients who receive hospice already qualify for Medicare. Everybody gets the same day rate. His client, my client, all get paid the same. So no competition thwarting there, no price gouging, and more importantly, no access issues. We weren't using our monopolistic powers, if they exist at all, to ignore parts of the community and chase others. We served everybody. Finally, Medicaid managed care requiring a choice it's not a CON review criteria. There is a CON review criteria for access of Medicaid patients to hospice or other services. But because you have only one, it's not assumed that you don't have that access. There's no statute and there's no rule that requires there be at least 2 hospices per region. The statute requires the agency to figure out what's the number per region. And for hospice, they just said 2 in every county. There's no evidence of any investigation of the needs of of Indian River County for Medicaid access, and there was no evidence that Medicaid patients were not being able to access hospice care. So in each of the special circumstances we go down, we find it's not an issue of a legal conclusion, special circumstance, therefore I win. It's a weighing and balancing of all the review criteria properly by the agency to say, you might have identified problems, some of those exist everywhere, you're not the guy to fix it. And the evidence also showed VNA is doing everything it possibly can to be the guy to fix it.
And you're telling us unless that was capricious or arbitrary, you need to stay out.
That's right, and the evidence I just cited was all supported by competent substantial evidence, witnesses and testimony from experts and lay people from the community. That is the question, not whether CSE, competent substantial evidence, supports other findings, but rather were the findings made by the agency supported? They were. So that kind of gets rid of your arbitrary and capricious. You can revisit legal conclusions, but not the weight of the evidence to be applied. In this case, I think the agency did a great job of assessing all the factors, applying the statutes. When that happens and it's not arbitrary and capricious and you follow the statutes, your duty is to affirm, and we hope that you will. I'd like to reserve the rest of our time for the agency.
Thank you.
Thank you.
May it please the court, my name is Julia Smith and I represent the Agency for Healthcare Administration. I think one of the notable things about this case is that there is a finding in the recommended order where a conclusion of law about whether special circumstances had been proven at all. And one of the things that was changed was the conclusion about underservice and that there was a special circumstance. However, when you look at our statutory criteria and our rule criteria, need is only one aspect and only one thing that gets weighed in all of that, as Mr. Frazier capably argued. It's a weighing and balancing, and not one of the criteria is fixed. I think if you look at the level of underservice that was demonstrated for one population, it was less than 10%. There were comparisons made to the compassionate care case. I think if you go all the way back down to the initial agency decision and the initial decision at the Division of Administrative Hearings, the amount of underservice that was alleged was 10%. That did not get an initial approval from the agency, and they ended up not demonstrating underservice when they got to hearing. Contrast that with the Continuum Care and Tidewell case involving Sarasota County. There you have a provider who operates as the sole provider within 3 separate service areas, 4 counties. And the level of underservice there was found to be 38.6% people being out-migrated, along with a factual finding about 40.8% people being given inpatient care for a service that's supposed to be provided mostly in the home by our own licensure standards and everything. Hospice should predominantly be provided in the home. So if you look at the level of underservice and compare it to the case law, it again gives it a little bit less weight, especially where there was, again, so much testimony from the community where they came forward in support of VNA, saying they didn't think they needed a new hospice. They talked about the van that goes into minority communities on a weekly basis, and they make it a point to keep a regular schedule so that people know they're coming and they can be used. You know, they can go there and for a nominal fee, and they would do it for free if they couldn't afford the nominal fee, was the testimony. They can get a health physical to get back to work. They can get a health physical for children to go to school or to play sports. And in giving those physicals, they can be a point for access to healthcare services for the community, for services that are in addition to hospice. And so they've made a real stride to go and do that. They're active in the community for outreach to break down those barriers. They have recognized that people sometimes have a problem with accepting hospice. And they had testimony from the people that go out in the community, a person for counseling who's paired with a nurse so that they can together talk to them about the prognosis of their disease as it progresses and what is likely to happen to them, and also deal with the grief and the feelings that you have that are complex about that type of decision.
Going back to your earlier characterization of the, I think, Tidwell case, and you talked about out-migrating. What does that look like in the context of there being service areas and county boundaries that we talked about earlier? Can you out-migrate out of the service area? Can you migrate across county lines? What
No.
is that?
Once you have a service that is provided by or regulated by certificate of need, you must obtain a certificate of need for a service area to go in there. The other portion of the comparison to compassionate care in Tidewell was the monopoly. There, again, 3 service areas, 4 counties with inpatient facilities just over the county line. In fact, there's a finding about building a facility across the county line. Well, an ordinary provider that has a single county where they have a CON and a license cannot cross those county lines.
Well, can a patient in Vero Beach go down to Fort Pierce?
The problem with that is that they'd have to leave their home. Technically, can they, if they can get some type of residential care at an inpatient facility, I suppose they might.
Is that what you meant by out-migrating? I'm just
Yeah,
trying.
well, in Tidewell, there was evidence that they were crossing, that something about that was being done to, they had a comparison to our need calculation that showed over 110% penetration of deaths within the county. And there's no way you can take care of more people in a county than have died there. And so part of the evidence was that between the hospital referrals and moving back and forth to inpatient facilities, the multiple admissions that they're allowed to count under state law were leading to a suppression of need using our need formula. Are we mindful of our need to increase competition? Yes, we are, and we found evidence of competition in Service Area 9A. It's highlighted in the briefs of Brevard HMA that they have sister corporations that have a home health agency and a nurse registry there, so people could get care in their home, albeit it would not be hospice, which is a unique service, but they could get care in their home for nursing care, for therapy, for other things, and there's definite competition for care for end-of-life services within the service area that is provided, albeit not by hospice, but it is provided by the nursing homes, the ALFs, the nurse registries and private duty nursing, and those other types of providers that a patient could choose to get care in the home and have it not be VNA. So we think that we're doing an adequate job based on the findings of fact that the ALJ had. I think if you look at the findings of the conclusions of law and how we changed them, what the order of the agency seems to be concerned with is preserving those as legal arguments so that a different service area under different circumstances could preserve those for another day. But what we didn't do is look back and say, hey, there was no competent substantial evidence. And where those findings of fact were left unchanged, and some of them give you, hey, there was testimony about this, but I find that the more reasonable and the more credible evidence is that, average lengths of stay, those were because most of the hospital referrals or the referrals to the hospice, a number of the referrals come from the hospitals in the local area. Those are going to represent more acute patients that are sicker. And yes, they may be closer to dying, but maybe it took that for them to be able to accept their disease and prognosis. So it can't all be blamed on the hospice, that it's just trying to take a certain level of patient. Also, the more acute care patients will have greater needs. They'll need things like hospital beds and medications and things that at the beginning of care when you first come on to hospice are a lot more expensive and can level off with those longer lengths of stay. So they're already incentivized to try to get people educated and then get them into hospice so that they can take the benefit of that with them throughout their disease course. This ALJ made over 110 findings, 110 detailed findings of fact, and where those have been appropriately given weight under the criteria. And in this case, the agency did look for competition. They did look for whether Medicaid patients seem to be being served. They looked at the populations that are historically underserved and the level of underservice, to not find that there's a special circumstance that warrants an approval. It's consistent with a case law that has also considered other types of facts that can lead to a finding of special circumstances or underservice. Our own need rule published zero fixed need or zero need for this service area for this hospice batch where this application was. And if we rely on that, they had quite a heavy burden to go forward and try to establish that there was need for a new program. We think that the agency appropriately modified findings of fact to preserve legal arguments, but also left the appropriate findings of fact unchanged, and that this court should affirm.
Thank you.
Thank you.
As briefly as I can, Your Honor, first of all, on the standard of review, I do urge you not to backslide. The arbitrary and capricious standard is a formulation of the Chevron standard of deference, which has been rejected as a constitutional matter. As to the issue of the monopoly, and I think this is key, Mr. McLemore, who's the head of ACA's CON unit, probably put it best in recognizing that there's people who are dissatisfied. They may have had a bad experience, a family member had a bad experience with VNA. And that he said that Brevard HMA did a good job identifying that there are residents who are dissatisfied. This is actually in the findings of fact. And he goes on to state that when there are dissatisfied residents in a single service area, no other competition, who indicate they would not recommend VNA, there won't be any hospice for them at all. And that's the point. That's the point, Your Honor. That's why we have that provision about monopoly service areas, because people deserve a choice. People in Indian River County deserve a choice in their end-of-life care, and this court should affirm that and reverse the order below and send it back to issue the certificate of need and allow my client to provide good hospice care. Quality was never an issue in this case. They recognize our hospice would provide good quality of care.
Thank you, Mr. Smith, and thank both of you for your helpful arguments. That concludes our OA calendar for this morning. We are adjourned.
All rise.